This is Barry Zelma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant, an expert witness, an author, and producer of these videos. Today it's time to speak about intentional acts, something anathema to insurance itself, since for there to be insurance, the events insured against must be contingent or unknown. They must be fortuitous, and intentional acts, by definition, are not fortuitous. In Automobile Insurance Company of Hartford versus Cook, a New York State decision from 2005, the court was faced with the legal question of whether an individual's homeowner's insurance policy afforded coverage when that individual was sued for wrongful death after killing a person in self-defense. On February 20, 2002, defendant Alfred S. Cook shot and killed Richard A. Barber, the decedent, after a disagreement over a business arrangement spun out of control. The decedent had entered Cook's home without permission, and during their discussions, Cook, armed with a handgun, retreated to his bedroom to retrieve a 12-gauge shotgun and then returned to the living room where the fatal confrontation occurred. Cook was indicted for a number of crimes, including murder in the second degree. He stood trial and was acquitted on all counts of the indictment. The jury concluded that the criminal case that the prosecution failed to prove beyond a reasonable doubt that the 120-pound Cook did not have legal justification for shooting the 360-pound decedent who had previously attacked and injured Cook after he refused to leave Cook's home. Finding no coverage, the majority held there was no possible interpretation other than the acts were intentional. In a case where the policy language does not refer to an intentional act, but rather contains an exclusion that applies to assault and or battery committed by any insured or any other person, application of the exclusion does not depend upon the perpetrator's mental state or whether the injured person was the intended victim. When the perpetrator was convicted of battery on the claimant, the exclusion applies regardless of the perpetrator's mental state. Back in 1978, the California Supreme Court, in a case called Clemmer versus Hartford Insurance Company, dealt with a shooting that resulted in the death of the victim. Regardless, it still led to a finding by the Supreme Court of California of a need for defense and indemnity. The court concluded that Hartford had no duties with regard to Dr. Lovelace's intentional acts in the killing of Dr. Clemmer, but was obligated to defend him. If there was a finding of non-intentional conduct in the shooting, however, it would be obligated to defend, and its refusal to do so was wrongful. One of the most extreme situations where an insured almost got coverage for an intentional act occurred in State Farm versus Patrick Frake. The California Court of Appeal reversed a trial court by concluding that an intentional act that causes injury, whether the injury itself was intended by the actor or not, is not an accident, nor is it an occurrence as those terms are used in a liability insurance policy. It thus concluded that the insurer neither owed defense nor indemnity to State Farm's insured because the loss was not fortuitous. Under California law, the word accident in the coverage clause of a liability policy refers to the conduct of the insured for which liability is sought to be imposed on the insured. The term accident refers to the nature of the conduct itself rather than to its consequences. The insured's subjective intent is therefore irrelevant. In cases where an intentional act is substantially certain to cause injury, determination of an insured's subjective intent or lack thereof is not conclusive with regard to coverage. Rather, an insured's protestations that he or she didn't mean to hurt anyone are only relevant where the intentional act at issue is not substantially certain to result in injury. Bad people sometimes do bad things. Forcing a woman to have an abortion, beating that woman and imprisoning her by threatening to kill her mother, cut off her fingers and force her to act against her doctor's recommendations are all intentional and abusive conduct that is excluded by almost every policy. Even after pleading guilty to a domestic abuse crime, Nikos Hecht had the unmitigated gall to sue his insurer for not providing a defense and indemnity brought against him by the abused woman. In Nikos Hecht v. Great Northern Insurance Company, a 2019 decision of the 10th Circuit Court of Appeals, Hecht had pleaded guilty to domestic abuse, an act that was proved, therefore, beyond a reasonable doubt. The actions of Hecht were clearly and unambiguously excluded. The allegation of the complaint, although it claimed some of Hecht's acts were negligent, the use of a Mexican nurse practitioner to attempt an abortion, those acts were totally intertwined with the abuse of an intentional acts, so that the negligent acts were part and parcel of the intentional criminal conduct. Assaults, given their intentional nature, would seem never to constitute an occurrence under a general liability policy. However, courts have adopted two divergent positions as to from whose perspective the assault is to be viewed in determining whether it constitutes an accident. Some courts have held this determination should be made from the standpoint of the injured party, while other courts have held that the determination must be made from the standpoint of the assailant, who is often, but not always, the insured. The Wisconsin Supreme Court, in a case called Schenner v. Gundrum, concluded that when an insured is seeking coverage, the determination of whether an injury is accidental under a liability insurance policy should be viewed from the standpoint of the insured. The court found that Gundrum's actions in setting up an isolated shed for a drinking party, procuring alcohol and expecting others to bring alcohol, inviting many underage guests to the party, and encouraging the underage guests to drink, especially an underage guest known to become belligerent when intoxicated, were intentional acts that violated the law. Gundrum's many intentional wrongful acts were a substantial factor in causing the plaintiff's bodily injury. Viewed from the standpoint of a reasonable insured, Gundrum's intentional actions created a direct risk of harm, resulting in bodily injury, notwithstanding his lack of intent. that a specific injury or any injury at all occur. Thus, the bodily injury was not caused by an occurrence within the meaning of the policy, and the insurer was not obligated to provide insurance coverage for Gundrum. Intent can be inferred in certain felonious assault or rape cases where the intentional acts necessarily cause harm. However, courts should be careful to avoid applying the doctrine in cases where the insured's intentional act will not necessarily result in the harm caused by that act. Almost any injury that one causes while driving under the influence of drugs or alcohol is foreseeable and arguably even substantially certain to occur. But an intent to cause those injuries is not generally inferred in such a situation because more than foreseeability or substantial certainty is required to infer an intent to cause injury. Self-defense is also a problem when discussing coverage for intentional acts. After the Supreme Court of California decided Gray v. Zurich Insurance Company, liability insurers provided a defense to their insureds in cases involving physical altercations where the insured claimed that he or she acted in self-defense. The reasoning employed by the courts to impose a duty to defend is that an injury inflicted in self-defense may not rise to the level of willful and intentional injury, which is excluded from coverage under the wording of most liability policies, or the public policy stated in California's Section 533 of its insurance code. When a person acts in self-defense, even though the person may intend to injure his or her attacker, the person is acting to prevent injury to himself or herself. The insurance company, therefore, may not rely upon an intentional acts exclusion to deny coverage where the insured acts in self-defense, at least in many, if not all, states. Battery is generally considered to be both a tort and a crime. Penal Code Section 242 provides that a battery is any willful and unlawful use of force or violence upon the person of another. A harmful contact, intentionally done, is the essence of battery. Perfect or traditional self-defense exists when the defendant has both a subjectively honest and an objectively reasonable belief in the need for self-defense. As a practical matter, an injury inflicted in self-defense is rarely, if ever, an accident within the meaning of a liability insurance policy. The defendant, in essence, intends to inflict the amount of harm that he or she believes is required to fend off the perpetrator. The act of self-defense is lawful and not wrongful. If a defendant commits a perfect self-defense, he or she obtains a defense verdict in the case brought by the person injured because his or her conduct was legally justifiable and not actionable. Self-defense is only available as a defense to a claim for civil battery if the perpetrator had an objectively reasonable belief in the need for self-defense. If an insured is unable to convince a jury that he or she had a reasonable belief in the need for self-defense, then the insured's conduct was deliberate, unjustified, willful, and actionable, and certainly there would be no coverage under an intentional act exclusion. In Swain v. California Casualty Insurance Company, the insureds were sued by their tenants for housing discrimination. California Casualty briefly defended the action and then withdrew from the defense on the basis that the claims alleged in the lawsuit did not constitute an occurrence. The insured settled with their tenants and then sued California Casualty for reimbursement and damages. The Court of Appeal affirmed a summary judgment in favor of California Casualty. In reaching its decision, the court noted that the insured's conduct inflicted an obvious harm to their tenants. The question of whether an insurance policy covers claims for assault and battery cannot be answered simply by looking at the policy itself. In California, the issue must be considered in light of California Insurance Code Section 533, which states, quote, "An insurer is not liable for a loss caused by the willful act of the insured, but he is not exonerated by the negligence of the insured or of the insured's agents and others," close quote. Courts have found that it is possible that an act of the insured may carry out his intention and also cause unintended harm. It found that self-defense is an excellent example. This video was adapted from my book, Zelma on Insurance Claims, Part 103, Second Edition, and is available as both a Kindle book and as a paperback from Amazon.com. If you found this video to be of use to you, please forward it to your colleagues. It's free. And please, in the interim, subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn about future blog postings and videos. Thank you for your attention.